This is the Team Reality broadcast live stream. I'm Eric Hartman coming to you from the authoritarian enclave of Westchester, New York.
And I'm Jessica Hockett coming to you from the authoritarian enclave of DuPage County, Illinois.
Westchester, New York.
And I'm Jessica Hockett coming to you from the authoritarian enclave of DuPage County, Illinois. I hear an echo too.
I do too. It wasn't there before.
No, it wasn't.
Let's see if Tracy. Hey.
Now it's gone.
Hello.
It is gone. Our tech issues are just working themselves
So sorry,
out.
guys. We're a newer broadcast, so just have some grace. Thank you.
But so today, obviously, the Illinois mask lawsuit. You guys got some really good news last week, and here in New York, we got some really bad news this week. But we are living vicariously through your victories, and we know that you've been having some issues with the ruling being understood by some of the school districts, some of the politicians, and so the rest of the country can kind of learn through you. We brought on two of the most amazing legal minds on Twitter. It is Tracy Olson and Robert Foho. You guys want to introduce yourselves?
Sure.
Go ahead, Tracy.
You go first.
Yeah. So I've been
You guys want to
a.
introduce yourselves?
Sure.
Go ahead, Tracy.
You go first.
Yeah. So I've been a. I'm getting an echo now too. So.
Yeah, I'm getting an echo too.
Go ahead, Tracy. Yeah. So I've been a. I'm getting. All right. I'm just going to start.
Yeah, I'm getting an echo too.
I've been a barred lawyer in Illinois since 1990. Practiced law in the belly of the beast of Cook County, Illinois, for 10 years, and essentially I've been in corporate in the insurance industry and a couple other industries since 2001. So I am a person who observes things and reads things. I've been involved in school law claims against school district for about 4 years of my career, but it's all been on the corporate end, not as a litigating lawyer. But I did do heavy litigation for 10 years in Illinois. Heavy litigation for.
I'm still hearing an echo, but I believe
Yeah.
Tracy finished talking, so I'll
Yeah.
go ahead.
Yeah, go ahead.
Heavy litigation.
My name is Robert Foho. I'm an attorney. I'm admitted in
an echo.
New Hampshire, Massachusetts, and Florida.
Yeah.
I've been having a lot
Go
of
ahead.
litigation
My name
involving
is Robert
challenges
Foho.
to
I'm an attorney.
COVID-related
admitted in
measures, including mask and vaccine
New
mandates
Hampshire,
in various
Massachusetts, and
settings.
Florida.
And I've been
I've
following
been having
a lot of this
litigation
news
involving
and these
challenges
developments
to,
in the law, and it's a very interesting time,
COVID-related
to say the
measures,
least.
including mask and vaccine mandates in various settings.
Yeah, I think we're getting a fair amount of echo.
News and developments in the law.
Robert, do you want to try and drop out and come back in?
Yeah.
I think I've isolated it.
Yeah, I
your
think we're
connection.
getting,
A fair amount of echo. I found that if sometimes when you have your headphones in, at least I do this, sometimes I forget to mute my computer and I can't hear the computer going through my microphone. And so that, at least where I've gotten bit by that. But anyway, Robert helped us out on our previous broadcast for Bonds for the Win. And as soon as he comes back in, I'll let him in. And he can reintroduce himself. But so Tracy, you are in Illinois, correct?
I am currently not in Illinois.
That's right. You're in Colorado.
Correct. We were part of the ongoing Illinois exodus. So we hit the escape hatch last year. And so I still am, obviously I've lived in Illinois the majority of my adult life. So I still have a lot of connections with Illinois and with things that are going on there. And, up until last year, I had students in public school in Illinois. So definitely kept this kept this, something I follow and legally and, from a, just from a political standpoint as well with, my friends that still have kids.
Well, we appreciate it because we've certainly had a lot of people flee New York, and most of our friends are still fighting from the glorious free lands of Florida and Texas and Colorado. So thank you.
You're welcome.
And Robert is back. Let's try this again. I think you have to unmute yourself somehow.
Yep.
There you go.
Well, thanks for having me. My name is Robert Foho. I'm an attorney. I practice in New Hampshire, Massachusetts, and Florida, and I've been involved in a lot of litigation challenging COVID-related measures, and most recently over the last year, these mask mandates and vaccine mandates in various settings, including schools. So I've been following the issues and the many developments in this area. I find it very interesting and fascinating, and I love talking about it.
Well, awesome. So I'm going to do a little thing because I'm naive. I'm more naive to this than you guys are, right? Jessica's living through it. You guys are lawyers, have been paying really close attention to it. I've been paying pretty close attention to it, but for the last 20 months, I don't know about you, but I've had to become an armchair virologist, an armchair epidemiologist. I'm all of a sudden like weirdly good at the political minutia. And now we have to become armchair lawyers as well, because there's so many different states and different laws and different approaches to this stuff. So because there's a ton of mask lawsuits going around right now, which honestly is a great thing. There's a ton of vaccination lawsuits, all sorts of stuff. I say go get them. But for the uninitiated, right, Illinois is it's a unique state. They do some things the same. They do some things differently. And what struck me about this is when I heard about the temporary restraining order approach, right, which is a different way at it than I had heard of. And then also the approach of this is it's sort of a state versus local issue in a slightly different way than we're trying to deal with it here in New York and other places. So can you guys just do sort of an explain like we're five rundown of like how did the lawsuit start? What was sort of the strategy going into it? And then, sort of fast forward through the different rulings to where we are today.
Sure, I can give that overview. I'll start with summer 2021. I think it was June or July when J.B. Pritzker said that schools could have local control, which they do have local control anyway under statute. But he said, sure, you can decide, school districts, if you want students to wear a mask or not. So then we saw kind of a cascade of different decisions with different school districts deciding different things, some mask optional, some not. I think I remember that CPS, Chicago Public Schools, maybe had not yet made a decision. Some of the bigger school districts maybe had not made a decision or were kind of leaning mask mandated. And then August 4th, 2021, the hammer came down. J.B. Pritzker was not happy that people weren't doing the safe thing. They weren't doing the right thing. And so J.B. Pritzker had to make sure that people did the safe and right thing. So he issued an executive order that people call the school mask mandate, but it's not exactly just the mask mandate. He invoked irrelevant emergency powers, as he's been doing all along, to tell school districts, to tell school boards, hey, school boards, you have to follow this forthcoming guidance document that's going to be from IDPH, our public health department, and the Illinois State Board of Education. And that is going to include the requirement for you to require students to mask. So then we saw school districts intimidated, reversing course and saying, okay, we have to implement this now. And one of the main rationales that I remember for school districts was we have to do this because of insurance. Like if we don't implement this, then we're more exposed, we're more liable. if somebody's going to sue us, a teacher or a student, if they get COVID at school and we weren't following the government's mandates. In fact, there was a letter that came down from State Superintendent Carmen Ayala. We can maybe post this later, but where she wrote to superintendents and she basically said, you have to follow this or you're going to risk losing your recognition status with the state and maybe some associated funding. And you're going to expose yourself and to liability. And I know Tracy can maybe speak to that a little bit more. So there was a lot of hullabaloo, but fast forward a little bit, and there was a lawyer, Tom DeVore. He's in Greenville, Illinois. And he took the approach, I don't want to speak for Tom, but he really took the approach, I think, of saying, well, what is a mask under statute? And who has the right to tell or make students mask as a condition of going to school? So he put out there that really under Illinois law, namely the Illinois Department of Public Health Act and associated administrative rules, that a mask is a form of modified quarantine under the law. He said, and this is in the administrative rules, but where he said it's a medical device intended to stop the transmission of disease. Further, because it's a form of modified quarantine, only the public health department has the authority to tell somebody that they have to wear a mask. And they have to do that according to a process. They have to issue an order to the individual or groups of individuals. And then once that person gets the order, according to these rules, they have the right to object. And it might be objections on, based on conscience. It might be objections based on matters of fact. And they have the right to due process and to go before a judge and have a judge make the determination about that. So Mr. DeVore's stance or his kind of approach to this was, hey, school boards, like you don't have the right, the statutory right to make kids mask. That's not your place. That's the health department's place. And hey, Governor Pritzker, you don't have the right to do this either, or to tell school districts to do it. And IDPH, you can't share your authority with or transfer your authority for doing this to school boards. So that's the approach that was taken. And through a series of events, parents from 146 or so school districts all over the state, they filed suits that were consolidated into one suit, along with teacher vaccine and testing mandate suit. And they filed against their school districts, the Illinois Department of Public Health, and J.B. Pritzker. I can't remember if ISB is on the suit. They may be. I'll have to look. But and they asked the judge for a temporary restraining order and said, like, schools can't do this. They can't do this, and they need to be restrained, at least for these students, and more desirably for everyone. So the ruling came down last Friday. And Judge Raylene Grishow, she denied the class certification for the case. So basically saying from a legal standpoint, this doesn't just apply to everyone in these school districts or everyone across the state, but she ruled in favor of the TRO. And so since that ruling has come down, and the actual TRO ruling and the restraining order is 29 pages long. It's a great read. I encourage everybody to actually read the order, not just go with whatever your district says it says. Read the actual order with your own brain. But she basically walks through like why all of this is illegal. Like this is against the law. All of this. And then she issued a restraining order for the plaintiffs. But she also in the footnote said, like, hey, even though, class certification wasn't granted, these emergency rules that ISB and IDPH came out with in September, they're void. Like these aren't lawful, and the governor does not have this unlimited power. It's restrained. He can't do this. So since this ruling came out, there's been a lot of debate on social media, at school boards, with people saying, is this binding? Who does this apply to? Because districts came out over the weekend and made different decisions. Some districts said, okay, yeah, masks optional, effective immediately, pending further notice, right? Like until we hear otherwise, because there's been an appeal, right? But that ruling has not come down yet. Other districts said this only applies to, if they were plaintiff districts, okay, this applies, but only to the plaintiffs that were on the suit. Everybody else has to keep masking, right? So those were kind of the two general responses. And in a way, I'm really glad that we had districts saying different things, because it really created this sense of injustice that I don't think a lot of parents had, and I don't think a lot of kids had. But for example, Naperville 203, which was prominently featured on Tucker Carlson last night, their board meeting was, that is, they were like, okay, no, mask required for everybody except the plaintiffs. Well, the next district over, Wheaton Warrenville 200, which is my school district, said, okay, masks optional. So you literally have kids like at Naperville North High School, and then Wheaton Warrenville High School, South High School, which is maybe 5 miles away. I haven't looked, but it's that maximum. Those students at Naperville North have to mask, and the ones at South do not have to mask, because there's a line of science. Right? And there's like different interpretations. And so we're seeing now in the Chicago area and downstate, we're seeing kids rise up, and we're seeing them, I'm calling it Rise of the Resistance. That's a Star Wars ride at Disney World. But we're seeing these peaceful, there's not violence. The kids haven't, broken out in fights with one another and aren't being like belligerent, but they're simply committing the crime of showing up and demanding, really, or even just asking. I don't know, the kids are even demanding, but saying like, hey, I'm not going
We lost your audio. While she fixes her audio, do either of you want to chime in on that?
Sorry
Okay.
about
Is she
that.
back?
Yeah. So yeah, I'm back. I mean, I'm just, kids are trying to, I think, honor the law, regardless of whether the their district said we're going to honor the restraining part of it. Kids are now really on their own invoking the statute and saying like, do you have an order of quarantine for me from the health department? Because if not, like, you can't really make me masks. And they're, in my opinion, they're right. So that's the long summary of what's going on right now.
Interesting. And
Yeah.
good for those kids for sort of reading and understanding, kind of the intricacies of the law. And also it's really interesting because from a medical standpoint, just a quick aside, is that line between those districts, is it similar to the line in restaurants where COVID only affects you when you're walking versus sitting?
These school districts literally abut each other on the south end.
So it's the same line as in the restaurants.
Yeah,
it's just
right,
geographic.
right.
Okay.
Yeah, what you're seeing here, this is when we talk about legal issues and legal arguments and challenges, without some real world applications, it's difficult to understand why they're important. There's this issue called preemption, which is kind of vaguely in this decision, and that is the notion that a local municipality should not be exercising authority that it doesn't have, and that instead belongs to a higher governmental institution like the state. So here in this decision, the Department of Public Health has certain powers, and the legislature charged it with the supreme authority over public health matters, and you have the governor delegating authority to school districts to enact these types of measures when they can't be doing that. And what happens is when you take that authority away from the state entity, which can issue a directive that's more uniform and applies across the entire state, you've got different school districts and municipalities doing different things, and it makes no sense, and it's confusing for people like you and me. Which district am I in? Which town am I in? Is there a mask mandate here? Is there, is there a vaccine mandate here? Can Does this store have capacity limits and so on and so forth? So that's the problem that arises in a practical sense when you have the governor delegating this kind of authority that belongs somewhere else.
Well, and I think Jessica gave a really good summary of the timeline and what the ruling said. But I would just add one thing to the timeline. School started in most Illinois districts around mid-August to the third week of August, and I will attest to all of my friends, coming to me and saying, "Okay, it's complete chaos," and then people started reading the statutes, or at least having, someone, maybe a lawyer or somebody, read the statutes and said, "Hey, this has to come from the Illinois Department of Public Health. The schools can't be doing this." And then legislatively or administratively, the rules changes, and it's how outlined in the judge's decision, came in late September. Isn't that right, Jessica? And this was kind of the judge kind of referred to this as kind of their workaround, that they, and notably, the Illinois Department of Public Health did not follow their usual process for revising administrative rules, which would be to have public comment. And then there's a committee, JCAR in Illinois, and what the acronym means escapes me. But then they review things, and then they issue what their decision is. And none of this happened in this instance. And then the suits ensued thereafter. But there were, and Robert, you might have been, if you were in the struggle in 2020 with some of the mandates coming down. The initial attacks on the mandates, either with work or with businesses being forced onto this, or schools were saying, this is violating my constitutional rights to wear a mask, and that didn't go anywhere, right? So
no. Yeah, what people initially, the challenges people initially brought were constitutional challenges. The lawsuits I filed at the beginning of all this in 2020, I started filing them in New Hampshire, and I always tried to find something other than a constitutional violation, because those claims are very difficult to litigate, to prove. They're very amorphous. The standard is always government deferential. So I started looking for ways to challenge the statutory authority of these government institutions enacting these mandates. For example, the rulemaking issue here. They issued these rules under the guise of an emergency, so they're emergency rules. And they bypassed the rulemaking process, which is a months-long process for enacting a new rule or amending a rule. And when I say rule, these are regulations passed by the departments, the executive agencies themselves, like the Department of Public Health, the Board of Education. To enact a new rule or amend a rule, they have to put out a proposed rule, invite public comment. There's a hearing, then they have to go back and amend it. There's very long, it takes months. They bypassed that here altogether and just issued a rule under the emergency provision.
Right.
I love to see how the judge challenged that premise. What's the emergency?
Right.
Delta variant that's been around for months. What's the emergency? You've known about COVID now for 2 years. What is the emergency that prompted these emergency rules? And there isn't any.
Correct. And when I read through this, I read the highlights of the ruling over the weekend, and then I digested the whole thing in the last day. And I would say, at least this is my opinion on the court's ruling. I think it was a measured decision. There was at no point where I said this doesn't make any sense. I think at a couple of points, the court even said the IDPH violated their own rules. ISB, the Illinois State Board of Education, violated their own internal rules. And like you said, what's the emergency? So I think, to me, from a 35,000 foot perspective, this ruling is really a lesson in civics and checks and balances, all that stuff that we learned in 5th grade and in middle school and in high school, about how government functions and how it was set up from a statutory standpoint of how things are supposed to go. And this was not done. And if people actually read the ruling, though, I think people, it's written like a court, it's written like a lawyer, but you can understand what the judge is saying here, that there's no emergency. You did not follow your own, procedures, and you tried to. It's delegation of authority where there is no capability to delegate that authority.
Right.
Yeah,
And just
go ahead, Jessica.
go ahead. Well, I was just going to support that from the ruling because I have it right here. 2 points kind of speak to what Tracy is saying on page 10, midway down. She says the IDP is limited by law to delegating its authority only to certified local health departments and has not been authorized by the legislature to delegate any of its authority to any other body of government in school districts. And then on page 13, she goes even further, which is a point I want us to talk about later. But she says the delegation of authority to school districts regarding public health and safety is an abuse of power and was never contemplated by the legislature. That's really important because as I sat through a board meeting last night, unmasked, in my school district, my school board still doesn't understand that they're showing their COVID metrics and hospitalizations and all these things. And I turned to my friend and said, are we at a health department meeting? I don't think these people understand that what Judge Grishow is pointing out is you actually don't have not only the authority, but the responsibility to really be doing any of this. COVID mitigation really isn't your job, is what she's saying.
Yeah, I like Tracy's not analogy, but the reference she made to this is a civics lesson, and that's what I think a lot. The decisions that come down this way really are a civics lesson. I think we're not teaching our kids civics in school adequately because we've forgotten a lot of these principles. And the judge makes the point, and one executive agency cannot delegate its own authority to another executive branch. Think of, for example, if the Department of Transportation wanted to put out a contract to build a service plaza along a state highway, and it says, you know what, we're not going to do it. We're going to have the Board of Education handle this. That would be asinine. Board of Education doesn't have the expertise or know-how. They don't have the people in place with that kind of experience and knowledge. So we would all balk at that. This is precisely what's happening here. The governor is delegating the authority, or the governor and the Department of Public Health are delegating authority over public health matters to the Board of Education, who they don't know anything about that area, that industry. And the other point I wanted to make regarding civics on page 9, the judge went through the various arguments that the state proffered in defense of these rules. And the second paragraph on that page, it reads, the state defendants also argue that the governor has unlimited authority to do whatever is necessary. If we know anything about the social contract, which I think all of you have a good understanding of that, given the opinions that you have and the positions you've taken on these issues, we cede some of our rights to the government in return for the government to protect us and protect those rights. That does not mean that the government now has unlimited authority to do whatever it wants. We're the ones with unlimited authority. We gave you some of that authority, and now you're violating that. And the notion that the state would argue that the governor has unlimited authority is as arrogant as it gets in this setting. And I'm glad that the judge went through those types of arguments and just shot them down, because he does not have unlimited authority. His authority is given to him by statute, and it's limited by the constraints of that statute.
Well, and I would say too, I listened to some of the oral argument when this happened, and I had to do my day job, so I didn't get to hear all of it, but I did hear the point at which I'm pretty sure it was the AG was making those arguments, and my jaw dropped. I'll be honest. I was like, well, yeah, you're wrong, but go ahead, because that's the position that you've been charged with taking. But I will say, I think what the general public needs to understand is that this ruling, even if you disagree with it, okay, it's still a court order, and it applies to the parties here. And if I might shift the discussion to more like, okay, what are school districts doing now? Because I think that's what people should understand, why there's a difference. Because a lot of people are saying the Naperville District 203 Board of Education meeting on Monday, which I watched all the public comment, people could not understand how their district could take that position. And when you have Wheaton, Warrenville, District 200 abutting that, Naperville, why they took a different stance. And all of them were defendants in the case. So if I can shift, can I shift?
Sure. Yeah, please shift. Pivot.
I think, just me reading between the lines here, I think it's pretty clear that one district took the position that it only applies to those students and teachers who were a part of the suit and not to the general populace of the school district. And I think, you could have two districts taking different stances for reasons that are not necessarily legal, but they know their constituency. They might know their teachers union or just their teachers. And that really explains it. I mean, to me, and Robert, maybe you have a different position on that, why there would be the two different positions. Say, I don't know. I didn't go and check to see if they have the same council. Jessica, I don't know if you know that or not.
Those two? I'm told that they do. That 203 and 200 have the same firm. I believe they do.
Because they're in the same insurance co-op.
Somebody can Google, but yes, they are in the same insurance co-op. And my understanding was that they do have the same firm, but I can double check that. Don't quote me on that, people. Okay. Don't say I'm spreading misinformation, but yeah, I believe they do. So,
I mean, my take on that is that, that's completely within the purview of those districts. They can make those decisions. And Naperville 203 saw what the reaction was by the students and the parents.
Well, the order, the judge didn't expressly decide the issue of whether school districts can implement their own mandates. He called into question. He called into question the idea of whether they could, and he specifically said there's been nothing before this that says they could. So we can already see how he's broadcasting how he would decide that issue if it was before him. Before her.
She. Just want to make that clear.
Her with the New York judge. So she's essentially forecasting that. But I think that this decision squarely applies to the emergency orders issued at the state level in the governor's executive orders, not to individual school district decisions or policies or mandates. So that's probably why you're seeing the different positions being taken, because they're still free to do what they want for now, even though we might disagree with whether or not they can do it.
Well, they're free to do what they want. I want to speak to that local control idea, because a lot of districts are seizing on that and saying, well, we passed a policy before the executive order came down, right? Or, hey, this is something that we would do on our own anyway. Okay. Which again, the judge kind of called that out like, yeah, maybe, but you've never done this before. And the evidence suggests that you did these things because, somebody was ordering you to do them, not because you came up with these ideas on your own. But let's go with that for a second. Just because you had your own policy before doesn't mean that it was legal. Like, you still have to, from an ethical standpoint, districts, you still have to look at that policy and say, well, do we agree with the point she's made in this ruling? Forget the TRO application for a second. Do we agree that with the points that she's made? And was our policy legal? Is it rooted in statute? Do we have the authority to do this under statute, even without the EO and the emergency rules? And B, just as important, did we, and she points this out too, although it's only one sentence, but it's kind of a little nugget there. Did you follow the right process for adopting policy? Did you have public comment? Was it at an open, under the Open Meetings Act, right? So those are 2 points that are like, careful what you say, District 203, careful. Do you see what I'm saying?
Yeah, well, when it comes to the school districts, they're this local control issue. That doesn't mean that they can just, again, do what they want. It does not mean that they have unlimited authority. Their authority is, again, granted by statute, and they're what they can and can't do is defined by what's in the statutes. It's usually in every state, it's usually expressed to some degree. They can only exercise the authority that's specifically granted to them. So they should take a hard look at whether or not they have the authority to do this, because if someone were to bring a challenge to any school districts that have implemented these mandates themselves, they're on thin ice for sure.
Well, and I would say, fine, do your process, school districts, revise, your policy. It's like dress code. I mean, Jessica and you and I have talked about it being, if it's a matter of dress code. I have thought, and I would put this caveat out here. This is not legal advice that I'm giving. And I guess Robert and you and I should have said that at the get-go.
I know we should have said that. Sorry about that. This is
Right.
not
That's
legal
okay.
advice.
So
We put it in the description of the YouTube, so we're covered.
Oh, okay. All right. So it's a discussion, but I've thought it's been my opinion from the get-go. School districts have a right, they certainly can, say, if we deem that there's some kind of, problem with the flu or something like that, we can require, a change in how you appear at school, what you wear. Okay. Something very nebulous like that. Those are still subject to the constraints of the Illinois and the U.S. Constitution. And there are exceptions to that. And there are, sometimes there's exemptions based on state law. Sometimes it's just, state constitution, like Colorado, for example. Colorado has, just like a personal choice type thing for school districts for K through 12 education. You can say, you know what, my kids don't get vaccinated. It's kind of like a conscientious objection, and we don't have to get into the Illinois law that was on that, Jessica, which was recently revised, which is, that's another whole, an entire program on that. But that's the whole thing. The schools have to still follow the U.S. Constitution, Illinois Constitution, whatever state they're in, and allow for exemptions to those kinds of things, whether it's dress code, whether it's, some other kind of behavior. And I think that's when you have what's happened over the past couple of days in several of the school districts across the state of Illinois saying, well, I don't have to wear a mask anymore. A judge said that. And these students are coming to school unmasked. They're being corralled into, the theater, into the gymnasium, and they're being separated. I don't know if you knew that was happening, Robert, but the thought of that has a whole other implication under federal and state statutes, as well as the Constitution, when you start doing that with students who arguably at this point, it's a political protest.
Right.
They're saying, I'm following a judge's order. You're telling me not to. Okay. The judge's order has more authority than the school at this point.
Mm-hmm.
Right.
Mm-hmm.
Well, the way they're treating students who are not complying, in addition to that conduct and the way they're treating that conduct by essentially segregating them, that brings in the application of the Department of Health regulations concerning quarantine and modified quarantine.
Sure.
and the due process protections that are built into that statute. That's not a constitutional claim by itself. It's
right.
The Illinois legislature built in those protections into the statute. The judge discusses that, but then that also, if they're protesting this measure by showing up and not complying, that perhaps for a future case that raises a First Amendment issue. I don't know. I'd have to look into that.
Well, actually, if I could just comment on that really quickly, because I brought this up last summer. And it's funny, I'm surprised a lot of people don't know this case, but, I was a history teacher back in the day, and, having been in education for 20 years, maybe this is why I know this case, but I cited Tinker versus Des Moines. And for those of you who don't know, Tinker versus Des Moines, was it 1968? I don't know that I'm getting the date right, but
it was Vietnam era. Definitely.
Right. It was the Vietnam era. And some students showed up to school with black armbands on, and to protest the U.S. involvement in the Vietnam conflict and what was going on there. And the school tried to say, like, no, you can't wear these armbands. They're disruptive. And so the case was litigated and eventually went to the Supreme Court. And we don't have to talk about all the implications of it, but it was determined that in that case that the school board, the school district does have, the right to some extent control what students are wearing at school, and obviously control the student environment. But these students were wearing something that wasn't in and of itself disruptive. It wasn't profane. It didn't say like F you, whatever, F you use or something like that. And that they were protected under the law. So what I was saying last summer when I cited that case is that was students protesting something that wasn't necessarily happening directly to them, although some of them could have been, maybe drafted after high school. But this is something that's actually being imposed on them. And so really students showing up to school and saying, I am protesting the governor's mandate, right? Or I'm protesting what my school is doing to me. It's unlawful. Again, now you have free speech protections, right? And if you're telling kids they can't do that, but they can walk out of school for a BLM protest, I don't know about that, right? And we saw that last year, 2020, in Chicago and Illinois, where protests for Reopen Illinois and against the mandates in spring 2020, those were derided and denounced by our governor and by Lori Lightfoot. But then when the George Floyd situation was occurring and that triggered all of those protests, what now it's okay to be outside in large groups, right? So this differential treatment is something that we've seen the whole time.
And I would just like to point out that those black armbands are exactly as effective as masks against COVID in school.
Right, that's true. Actually, if you put the black armband on your face, you'd be in compliance with most face covering mandates, technically. So so I think I guess, and again, I'm not a lawyer, but I followed this so closely that I can still, say or feel confident enough in expressing the opinion that these school districts that chose to not go mask optional right now and not take the cover that Griswold was offering, they are creating a lot more problems for themselves, I think, legally, more legal exposure. Don't you think? Am I crazy?
Well, I can see the rationale for, can you hear me? Is it okay?
Yeah.
I can see the rationale why some school districts made the decision to not go mask optional simply because they knew the TRO ruling was going to be appealed and they didn't want to do a yo-yo. But I mean, I think, the genie's out of the bottle. I mean, Jessica, you pointed out the students perceive an inequity, when they drive, 2 miles away into another school district and those students are mask optional.
So super quick, this is a really good point because here in New York, we had a good ruling a couple weeks ago. It was on a Monday afternoon. And the next day at 4, there was a stay, right? We had a victory and then they had this emergency thingy. It's legal talk. It's an emergency thingy. And the judge said that there's an emergency stay. And then a couple of days later on Friday, they accepted written requests for the appeal and the stay. And they granted the next Monday the stay until the appeal, which is, obviously like, I don't know, a year away or something. But what happened here that disallowed a stay? Because I totally agree. Once the genie's out of the bottle, once these kids in these districts can experience a mask-free school environment, it's hard to go back. And I think that in New York, our government, realized that and pounced on this. Why didn't that happen in Illinois?
I have no idea.
Yeah, I don't know, but I haven't looked at the when there's a decision like this and one side wants to appeal. Usually there's some provision in a statute or one of the applicable rules of procedure that provides for a stay. You have to file a motion though. And it depends on what the basis is for the stay, if you can demonstrate that. So I'm not familiar with that provision of procedure here.
My understanding is that there was a mistake in filing the stay, but I don't know. That's
I didn't
my
know.
Understanding.
Yeah, so the state could have asked to have it stayed. I didn't go and look procedurally to see what they actually filed. I don't know if that court I did try to look over the weekend to see if I could access it, and I might not have the access, the online access, to go look at the procedural posture of it. But the fact that it hasn't happened, I mean, tells me that they did make a legal error in doing the appeal, and they probably, it would have been good. I mean, I thought when this ruling came down, it would have happened like in New York, Eric. I thought it would have been okay, immediate stay, but you have to ask for it. I'm 99.9% sure in Illinois you have to ask for it, and if they didn't ask for it timely or in the right fashion, and they just
hilarious,
right? And in New York, we learned that, again, armchair lawyer here. There was a really interesting. I don't know if you guys caught this, but it was very interesting because after the Monday ruling in our favor, the education department of New York State put out a statement for the school boards, and it said there's an automatic stay in place. And it was very interesting to see the scramble that evening and the next morning amongst lawyers, and we figured out very quickly, not me being a lawyer, but that there was no automatic stay, and it was it was enraging that the state, who should know better, right? Again, normies like me didn't realize at the time that there are some automatic stays, but this was not one of them. And the parties involved should have known that, especially for the state. And the state came out and issued an official decree that said that there was an automatic stay in place, which influenced our school boards, right? So a lot of school boards decided not to do it under the auspices of, or the assumption that there is an automatic stay. So, good times.
Yeah, and I haven't seen any discussion about that with regard to this TRO. All I know is that it's in effect, and it hasn't been, and the enforcement hasn't been stayed.
Well, the longer the genie's out of that bottle, you can't put the genie back in the toothpaste tube.
Mixed metaphor, nice.
Yeah, way to go. Yeah, I mean, and what we're seeing now too, I'm scrolling through the comments. Somebody asked a question, I think about Naperville 203, and this is true in District 200 too. Some of these districts pass these policies, this like face covering policy, that aren't rooted in any statutes at all. Like, you look at the policy and you're like, oh, look, this is in their policy handbook, but there's no statute cited. So people should definitely look at that. Other districts I've seen have, because people are sending me stuff and I'm like, what was your district's previous policy rooted in? Some people are telling me that their district cited like student behavior policy. I'm like, I'm not sure about that. Other people have shown me that their board is just citing the general ability to make rules and to protect themselves against liability. I'm not really sure about that either. Again, especially in light of how the IDPH Act and administrative rules define what a mask is. And I think for me, it's always gone back to that question, right? I like to go back and say, okay, big picture here. What's the question? And actually, this is true not just for schools, but for the whole country. What is a mask under the law? And who has the right to tell you to wear one? And in what circumstances? And the truth is that in most places, a mask has not been defined legally. So for me, in Illinois, at least, I can't speak for New York or Massachusetts or other states, but I see only two places. It's a form of modified quarantine, if you want to say it's a medical device, or it's simply a piece of clothing, right? And could a school district say you have to put a piece of cloth over your face in order to come to school? Well, sure, because they have the authority to make a dress code. They could tell you to wear a scarf every day. They could tell you to wear red pants every day. Public schools can under Illinois law. The thing is, though, dress codes are subject to religious objection. And so
medical exemption.
And medical exemption.
And I would add that a mask before 2020, a mask was a non-pharmaceutical intervention.
Sure. Right.
I think I had a judge make that argument too. Well, the school has the authority to require dress codes and regulate the dress code, so therefore they can require students to wear masks. But again, it depends on what that statute says,
Sure.
and how clothing is defined or described. But clothing traditionally has never been defined to include wearing a face mask. So that invocation of that kind of authority is dead on arrival, in addition to potentially other challenges that one could raise to a policy based on said statute.
Yeah, I mean, it's obviously an attempt, right, at a medical intervention. I mean, I get sort of a legal, argument that it's a dress code or what. I mean, look, I'm for whatever we can use, whatever technique exists to get these things off our kids' faces. But back to reality for a second. This is obviously masks. They think that they have a medical benefit, right? And it's based on this sort of this assumed responsibility to keep people safe against their will.
Again, I mean, show me where that is in the law. That's my thing. Tell me to wear one. That's it. Those are the two key questions. And for anybody's school, I don't care if it's a private school or a public school, those I think are key questions. Why do you have the right, or what gives you the right? And I've worked in schools for 20 years. And I know people push back with me on the dress code issue, but anything that has to do with what students can or can't wear on their person in a school, even things having to do with hair. Actually, we have a hairstyles discrimination portion of our dress code statute now that was passed late last year. So anything about student appearance, schools have rules and guidelines about, and they're always justified by health and safety or minimizing disruption to the educational process. Now, I would say there's nothing more disruptive to the educational process than covering somebody's face, the students or the learners. Hello, but Governor Pritzker in late August, when he was talking about enforcement, he's like, well, schools have always enforced dress codes. So he was saying that's kind of how he saw this being enforced. Right. And, one more thing, Tracy, and then we'll go to you. Teachers hate enforcing dress code. They hate it, right? Some girls' shirt is too low. Some boys' pants are, hanging down. They hate it, right? Some teachers are kind of more dress code enforcey than others, but a mask, this is the easiest thing in the world to enforce. And I feel like the enforcement of masks is like dress code enforcement on steroids. And it has created this culture in schools of like oppression where, we're really interrupting instruction and interrupting social development and relationships because of enforcement of the mask, right? So even if it is dress code, I've got issues with it as part of dress code as well.
Well, I was just going to say, the reality is, at least in Illinois, the schools are not even recognizing any exemptions to this. I haven't heard, maybe you, Jessica, your finger's more on the pulse.
Same here.
That part of it.
Nothing.
Is that they're saying there is no exemption that we will grant. And that was attempted in Illinois. And the Healthcare Right of Consciousness Act, which was the Illinois statute passed, 20 years ago, that the Illinois legislature in their 2 weeks out of the year that they've been working over the last 2 years, wanted to revise and to say, okay, but this doesn't apply to COVID. You can't you can't cite this statute. That's the problem. I mean, there's Illinois statutes, there's, U.S. constitutional bases for exemptions, medical exemptions, if you got one, that the vast majority of these school districts, from what I've heard, were not recognizing.
Yeah, same here. We got our kids were having really bad headaches and anxiety and dizziness, and we actually got them seen by a physician, and it's very hard to do. You can't find a physician that'll stick his or her neck out to give a doctor's note, but we got them, and we presented them to our school, and they said, "Go pound sand." And it was a little weird because,
Yeah.
you know, we've never used that before, but, you know, before COVID, you know, doctor's notes were, you know, they're honored. You know, if you say my kid has nut allergies or blah, 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 like there's a responsibility on the school or the administration's part to sort of honor those, because they're not, you know, they're not done willy-nilly.
Well, and what's interesting too is that the Illinois dress code statute, and why I've been on that since last year, is because it actually isn't subject to board approval. So for me, and lawyers, you can affirm or disconfirm what I'm going to say, but an exemption implies that somebody has to grant it to you, right? You are now exempt. But the Illinois dress code statute says, and I don't quite have it memorized, but the gist of it is this, that if a parent has religious objections, they have to present a signed statement of those objections to their board, and then their kid doesn't have to follow it. They don't approve or disapprove of it. That's it. And so I think there was a massive failure. If we go back to April 2020, sorry to blame lawyers here a little bit, but I actually blame churches first and foremost, because I think we accepted all too easily the idea that there was no valid objection of conscience or religion that could be made to the forced covering of the human face. And the entities that should have stood for that first were churches and synagogues, etc. And there's plenty of support in the Hebrew Bible, in the Old and New Testaments. I won't get into all of what that is, but instead it was like, oh, love your neighbor, wear a mask, which I could talk all day about the errancy of that statement. However, without that, then it was like, well, nobody, forget religion for a second. Well, no, there can't possibly be any objections of conscience to the covering of the face as a condition of going to the grocery store. What? Do you want to kill people? Do you see what I'm saying? Like we dropped the ball at the very beginning, I think, on all of this. And now we're back to that, right? And then we're wondering why 2 years later we have a maskdemic on our hands.
Well, I mean, the issue of a religious exemption, under the law, and it's usually the same standard pretty much everywhere, you have to have a sincerely held religious belief. Now, before COVID, when someone requested a religious exemption based on a sincerely held religious belief, the recipient of that request wouldn't really do much digging to ascertain whether or not it was in fact a sincerely held belief. Enter COVID, and people objecting to masks, people objecting to vaccine mandates, and citing religious beliefs to support those objections. Employers, schools, other people in authority have certainly taken a much deeper dive into determining whether or not the person's religious beliefs are in fact sincerely held. And I dealt with this a lot. I helped a lot of clients draft religious exemption requests when the employer vaccine mandates came down, and there was a lot of scrutiny being applied to those requests, and employers were digging into people's medical history. You know, they'd ask them, well, you know, you got the flu vaccine 4 years ago. What's the difference with this one? And so on and so forth. There were a lot of different inquiries like that, and there's a lot of back and forth. So I think we can all agree that there were people opportunistically using religion all of a sudden to object to a vaccine mandate. And so that's why employers, schools were applying a lot of scrutiny to those requests. But I mean, I agree, it's a valid request, and so long as you do have a sincerely held belief, you do have a right to exercise that and object to it.
Mm-hmm.
Let me ask a question about the emergency status. You guys alluded to this at the beginning. And again, I don't know these Supreme Court rulings inside and out, but I do remember when the Wisconsin Supreme Court smacked down their emergency order fairly early on. That was kind of a big deal, kind of big news. There seemed to be some precedent prior to this in terms of how long an executive could claim emergency. Can either of you speak to that? Because there was precedent before this, correct?
Well, just speaking of Illinois, This was a subject of hot debate in April and May of 2020, whether or not the governor of Illinois had emergency powers beyond 30 days. And that was some of the original challenges. I mean, Jessica talked about, the churches. There were churches, for the most part, from what I recall, these were all independent churches. This was not, the Archdiocese of Chicago or Joliet, or the Lutheran churches organization in Illinois. But independent churches did challenge the closures. This is before we were even talking about masks. Right. We were talking about complete and utter closures and challenging that. And though that was the basis for part of their challenge, to say is that the governor has no authority beyond the 30 days, and the attorney who's representing the students and teachers in this current litigation about the masks, that was one of the main arguments, is that the governor has no authority beyond 30 days to keep declaring continual emergencies and without a meeting of the legislature. That's the fix in Illinois, is that you go in and you have the legislature say, okay, we're going to say, okay, this is the law, for the state of Illinois. And now it's a different story whether or not the legislature can then turn around and make a law that says we delegate all of our authority to the governor to do this. Probably would not pass constitutional muster.
Yeah, I mean, it depends on. It depends. It's state by state. Every state has, I believe, every state has an emergency powers statute, and they're all worded differently. Illinois has a 30-day cap. Other states like New Hampshire, Massachusetts provide a much more unlimited duration, and so you have some states that were perpetually in a state of emergency. For example, New Hampshire statute permitted the governor to extend the state of emergency every 21 days and cite the same reasons as before. And New Hampshire was in a state of emergency for like a year and a half. That's preposterous. Right. These statutes, these emergency powers are not intended to last so long. And you have governors issuing 90 emergency orders touching upon every facet of the economy. These statutes are supposed to enable a governor to get to handle a disaster, some kind of an emergency that's immediate, that's beyond local control, and that's of limited duration. Some states have statutes which much clearer limits, like Illinois, but other states do not, and that creates an issue of whether or not separation of powers are being violated. Because when a governor perpetually extends a state of emergency declaration, you essentially have a mini legislature in the state capitol or in the governor's mansion creating new laws out of whole cloth, and that's not appropriate. That's again going back to Civics 101.
I was just going to say that if we bring ourselves full circle here, is that what people need to remember: 3 branches of government. The legislature is a check on the governor, or federally the president, and the judiciary is a check on both of them. And this ruling in Illinois is a lot of people very upset. It doesn't help that the Illinois governor comes out and says things about this judge and about her ruling and how it's unsupported. It doesn't make any sense. I don't know exactly what he said, but along those lines. But in the end, if people really read this ruling and get through the legalese, I mean, that's how she outlines how it's supposed to work, and that the rules weren't followed. Mm-hmm. And it's not like she's not making a political decision on masks. This is not a ruling about I don't like masks, so I'm going to get rid of them.
Right.
So
well, that was the crux of the suit in New York, which was you can't create a mini legislature in the executive branch. Again, Civics 101. It seems pretty obvious to us, right? Like, and I learned something as a normie, right? Because, I mean, correct me if I'm wrong, but for public health to create a rule, there has to be some sort of legislative law that's been passed and signed that they can sort of base that ruling on. And our public health has gotten so far afield of any potentially applicable law. They were trying to, the sticker when you go in the bathroom and it says employees must wash hands, right? They were sort of basing their mask vax policies on that workplace enforcement by the state Department of Health. And the lawsuit was like, this is crazy town. You don't have that authority. And it was very disappointing to see the judge grant the stay because, and it comes back to this idea of normalcy. Like, what normalcy should be the default, right? They should have to make the case to take us beyond this, right? They should have to make a case that masks, prevent X amount of COVID consistently and measurably in order to vault over the barrier of normalcy. And they've completely 180'd this thing, and they've established this new normal that we're having to kind of kick and scream and fight and sue our way out of. And it's absolutely evil. It's unconscionable. Like, it's so frustrating.
Well, I think I agree with what you've said. What has happened in the last 2 years is that people think public health is up here and it dictates all. And that's not how our system works. I mean, all state departments of public health have any kind of authority because it's been granted to them from the legislature and
Right.
Before then from the Constitution. Like, there is a basis to legislate public health, and then the legislature grants certain authority to a Department of Public Health, and then they promulgate rules and how they're going to operate, which may or may not, be correct legally, and can be declared as, unconstitutional or no basis, and they have no authority to do it, however you want to describe it. And I think that's what people need to understand mostly, is that in Illinois, this is how it's supposed to work. And in other states, they may, have similar rules, and there has to be a check on the power, and that's comes
Right.
from the legislature. And when there's a check on power, then the executive branch, governors, and all of the state departments, whatever they may be, have to follow that, and their rules can't go far afield.
But they did.
But they did.
They
Right.
right,
They
and
did, and they got called on it, and this is the result. And this the schools that went mask optional in Illinois seem to be, with the exception of a couple of teachers taking some actions and moving kids around based on whether or not they use masks, they're saying it's better overall. That's the
Of course it is.
anecdotal proof, and it's chaos. Naperville 203.
Right. I mean, because they're trying to, it's so funny because it's like, it's ironic, by not kind of just restraining themselves, forget the judge for a second. Like, how about you restrain yourselves and give mass choice? But by saying,
Right.
no, we're not going to do that, then they create this environment where they're trying to restrain everybody, right? From doing what they want, you know what I mean? It creates more tension, and people are done. Just to invoke, Barry Weiss for a second here, #done with COVID. And it's not because COVID, is going away, or that people aren't still dying from or with it. It's just, we really do have to move on. It's long past time to move on and try to make sure that this doesn't happen again. But first it has to stop, and it hasn't quite stopped yet.
I would insert some accountability in the middle of that sandwich. We need to figure out a way to, again, short of the gallows, there is a severe lack of responsibility by the people in the administrations, in the bureaucracy, who have been really major drivers of this madness, and it's so destructive. And I think it's going to be not good if they can kind of get off by going, boop a doop, we tried, but we're bureaucrats and there's nothing, we can't be fired and we can't be held to account. I don't think that that's going to go over well. There needs to be some sort of mechanism, because what we were just saying is absolutely true. Civics 101, they were not allowed to do most of what they did. So A,
Right.
why? B, how, if we do that, we get in trouble, which is why we don't do that. So why can they do that and not face any consequences? And again, it's I'm not out for blood necessarily, but again, you don't learn if you don't do this. You have to go through this process of being very honest about what happened, who did it, you screwed up, you didn't, or whatever. But like it feels like we're trying to skate past that middle portion, and that's where the meat is. Oh, absolutely.
Well, this judge, okay, so Judge Grishow's ruling is a piece of the accountability. There's ballot box accountability, or in Illinois, mail-in ballot accountability. So, I mean, the thing that's heartening to me is that when you have a judge rule the way that they're supposed to, and I defended a lot of clients in court and took my lumps, whether or not I agreed with it or not. But if I could understand a ruling and say, okay, yeah, I understood why they did. That's why every town needs two lawyers, because there's always two sides, and there's different legal arguments that can be made. But I think the thing that is heartening to me is that this is the accountability, and this is how the system's supposed to work. The judge is putting the check on the governor and IDPH, ISPE, and that's that should happen, and that's what did happen. And
it's just too bad it didn't come sooner. It's late.
Well, but you see, tyrant's going to tyrant.
Right.
So I mean, if you think you have the power and you're just going to keep exercising it until someone tries to stop you, and that did happen. I think I want to say, with the churches shutting down, there was one church that was defiant of everything that was going on in Chicago. It was an independent church. I want to say it was a Romanian church.
A Romanian church in Niles, yeah.
Right, in Niles, not in Chicago, in Niles. Yeah. And there was other shenanigans with the mayor of Chicago trying to block a parking lot to a church on a Sunday and give tickets to everybody. So, all it takes is a few people standing up, getting a lawyer and standing up to this stuff.
Well, and if I remember I'm just trying to take myself back to that time frame. And I think one reason why people were sort of willing to go along with everything, besides the, fear, right, is that, it started like just 2 weeks, right? And then 2 more weeks, and then 30 days, right? It's this slow boiling frog. And so maybe, some of the court decisions, maybe initially at the time, it was like, well, this is an emergency. Well, this is an emergency. Emergency, right? So I think it's not like anybody said in March 2020, okay, you're going to have to mask for a year. Like nobody said that. It was presented as this temporary thing. All in Illinois, do this together. And the government and public health overlords were really scarily effective at changing people's minds about their responsibilities to other people, right? They redefined what sick was. You could be sick. You could pass it to someone else. Who could pass it to someone else? Who could pass it to their grandma? And then they'll die. And like, hello. And they made it this moral thing. They turned it into a war or a battle in a really kind of sick and twisted way. That's really, when you think about it, an affront to American values. I mean, I believe that when I take responsibility for my own health and the people whose health I'm responsible for legally and before God, that has a societal benefit, right? I can't succumb to other people's demands of me, right? That's untenable. And it just creates a culture of fear. So anyway, I mean, I think that's why we are, from 2 weeks to 2 years, right? I mean, that we're coming up on that. And now we see these Democratic big blue governors and mayors maybe kind of trying to shift a little bit, because State of the Union is coming up. Joe Biden is a disaster as a president, and I don't care if people voted for him or not, but he's been an utter disaster. And 2 weeks to 2 years tagline is coming up, right? What a failure! What a failure on every level, I think. What about the insurance maybe you can speak to this, Tracy, and I know it's not legal advice, but insofar as school districts kind of making the claim that they have to do this or that for their insurance liability or to be protected, we have to have kids masks because we might get sued if we don't. So what do you think about those points?
I always say the lawsuits are going to happen no matter what you do. Okay. So in this, you just have to pick what's your battle.
Pick your one. Yeah.
I've never, okay. First of all, from an insurance perspective, insurers do not like to give prospective hypothetical opinions. And I think Robert can back me up on that. Like a person that has an insurance policy goes, well, what if this happened? And I can just say, that's just not something that normally is done. There were school districts that were saying we will lose our insurance if we don't follow CDC guidance or, Illinois Department of Public Health guidance or whatever. They wouldn't lose that current insurance policy. Maybe their premiums would go up, but the truth of it is a lot of school districts are part of insurance co-ops or insurance pools, whether that's a product offered by an insurance company, or if it's just literally like it's a statutory creation. Illinois allows it. A lot of states allow public entities to pool their insurance together because they're considered one type of risk. But that's a boring topic. I've never understood if there's legal advice coming from counsel saying you're going to get sued because kids are going to catch COVID at school. I've never understood. Yes, there could be liability for that, but those cases are extremely hard to prove. How can you show that, even with contract tracing, that child or that teacher has a life outside of the school district buildings? So how are you going to prove where they picked it up? It's a virus.
And this is very similar to what we've run into with a lot of doctors, right? There's an artificial consensus out there of medical, people, because, a lot of them do follow the narrative line, but there's a lot of them that don't agree, question the CDC, question, Fauci, question the state guidance. And what we found very early on was that these doctors were extremely reticent to speak up. And it was primarily because of their insurance. And, a lot of doctors are, parts of networks, and there's insurance, that has to do there. And and from a medical standpoint, they did not want to go against the CDC or publicly come out and question or even seem like that they were. Because again, it's like, could they win? Maybe, but doctors don't operate that way, right? Like if there is a question that they might be in sort of some sort of liability danger, they sort of nope right out of there. So this is a problem.
Yeah, well, and if I could just invoke SCOTUS for a second here from January, and then I want to go to what Robert was going to say, is, they said it really well in their OSHA case ruling. They said, although COVID-19 is a risk that occurs in many workplaces, it is not an occupational hazard in most. So they were talking about for workers. COVID can and does spread at home, in schools, during sporting events, everywhere else that there are people, that people gather. This kind of universal risk, there's the key word there, is no different from the day-to-day dangers that everyone faces from crime, air pollution, or any number of communicable diseases. Right there, right? So right there, school boards, like, sorry, it's a universal risk. And unless you have a legit outbreak, and I don't mean outbreak as defined as 2 epidemiologically cases, okay, of positive people. That's not what I'm talking about. I'm talking about the kinds of outbreaks that would close at the superintendent's discretion, by the way, under the law, but close schools during flu season, right? And there's no hard and fast metric, but like from my research around this, from media reports and articles from the past, it usually takes like something like 15 to 20% or more of actually sick students and staff for a school to close. St. Charles High School, Illinois listeners, you know where that is, St. Charles East. I think it was 27 or 2018, something like that, where they had like 800 kids and staff that were out. And so they closed for a couple days. There was a health department investigation. That's appropriate, right? When people are actually sick, so that you can trace it maybe to a foodborne pathogen or
if it's like Legionnaires or something.
Absolutely, right. And there were actually sick kids, and it was, I think, norovirus, right? But they didn't close for 3 weeks and contact trace everyone or tell everybody that they had to get a test or quarantine for 10 days until right? When we think about this, it's absolutely crazy. So we need to get back to sick being sick and school districts actually focusing on the things that are their responsibility and over which they have control under the law. Robert, what were you going to say earlier?
I was just going to offer another point on the insurance issue. That's just not a credible argument. As Tracy stated, they're not going to lose their current policies. These policies are not premised on them undertaking COVID mitigation measures. And then, in addition to the causation problem that she identified, how do you know a kid got COVID in school? The kid has a life outside school, so there's a major causation issue there. Then you have to have a loss. There needs to be some kind of damages. We know that children don't have an issue with this virus. And then again, if you're going to find out that someone else got COVID from the child and then suffered some kind of serious symptoms or was hospitalized, the causation issue comes up again. So that's just not a credible argument. I mean, whether insurance policies require this stuff in the future, I don't know. I doubt it. But it's just not, that argument doesn't work for me.
It's still super quick. It all comes back to the myth of the asymptomatic super spreader.
Right.
It really does. And that is such an insidious, sort of unhelpful thread that has it's just simply not true, thankfully. Right. Kids are, safer, schools are safer. And, there is really no asymptomatic super spread, but everything is based in this, better safe than sorry public health planning. And they act like there's no downside to being better safe than sorry all the time. And I think you look around and there's a lot of downside to that.
Well, and I think that's really the second wave lawsuits in my opinion, because year of kids basically having remote school or a pause, an adaptive pause, as District 200 and Wheaton calls it. I thought the real liability was denying education. And no one's really, people have been very accepting. People have been very understanding. Parents have not, collectively lost their minds and just said, I'm just suing the school because of what's happened. But I think that's going to start happening now. And I've always thought that denying exemptions to masks, medical exemptions and religious exemptions would be something that would come out relatively quickly. I haven't seen it. I mean, maybe Robert, you can comment as to that if you're looking at this, nationally or regionally where you're at. But I think now there's going to be I don't know how they're going to prove it, but there could be parents trying to say, okay, there's been massive damage to my children, psychologically. Yep. I could just see those, whether or not they can prove it. I'm not saying they have a good basis in law or it's going to be proved, but those will be the next wave of suits that come out of this.
I say bring the suits.
Well,
bring it. Bring it.
I want to sue all of them into oblivion. I don't even want the money. I just want them to go down in flames.
Yep.
Yeah, Robert.
Okay,
what do you think about that?
Yeah, we got to wrap up.
Okay. Oh yeah, I guess we are at that point.
Yeah, we're gonna wrap up. But
I'll agree with you on that.
Okay.
Yep. I concur. The gentleman concurs. We're going to wrap up with just a brief clip. John Kerr, who's actually a sports journalist in the Chicago area, has been documenting and following the rise of the resistance, peaceful resistance, at Chicagoland high schools. And he this morning posted a nice clip that I love that all these kids have phones. Right? Because they're like, there's going to be so much evidence. I mean, lawyers, like everything is documented. Administrators, be careful.
It's great stuff.
It's fantastic, but it's a recording of a student at which high school is this? Is this Vernon Hills High School, Grays Lake, maybe? But there's a student recording, and then we're going to hear the invocation of the law. I think from a fellow high school student talking to a teacher or administrator. Go ahead and play that, Eric. Let's hear what he says. This is a good summary.
You can't use it off of Pritzker's mandate because that was ruled unconstitutional void, and you can't use it off the Illinois Department of Public Health because it's also overturned. So is it just the school's decision to make every single student quarantine and wear a mask? And if so, we should all have our day in court to represent why we need to wear a mask and give us our due process. Instead of just assuming we're guilty and masking every child in the school, you need to give us our day in court and explain to us why we need to quarantine and wear a mask around individuals.
Here.
Amen. Amen.
It was
Love
so good. It was so good, and that's what the kids need to do. And it invoke their rights.
That's what we all need to do.
It's what we all need to do. It's what we all
Right.
do peacefully. Yeah, exactly.
Well, I just want to say my in conclusion, I think this has the silver lining. There's a few silver linings of COVID is that this has gotten people involved. They've woken up. And
Agree.
they figured out, hey, maybe I need to start paying attention to my local elections. Because these are the people who are actually impacting my life and my kids' lives. These are good things. I mean, people attended school board meetings. I had never attended a school board meeting before 2020. Never. And I vote in every single election. But, I pay attention to it, but people are now digging into things and figuring things out. It's
Totally
woken
agree.
up parents to run across the country. It's really a mom movement. So I would encourage dads to get involved. Don't just say, oh, it's my wife's thing.
Hey.
No, it's not my wife's thing. It's everybody's thing.
Yeah. Well, awesome. This has been such a great discussion. I hope that
So
school board
informative.
members watch this, superintendents, governors. There's some good food for thought there. And any parents of Illinois students or Illinois students who are watching, or actually anywhere in the country, keep going. Keep going. We are with you. And anybody can follow any of the four of us on Twitter. And I'm always happy to, if I see your reply, I'm happy to reply with any resources or links or things like that. And Eric, I'm sure we'll follow up on this little
It'll keep going.
broadcast. Yeah, we'll follow up on Twitter, maybe with links to other things that people were requesting. So thank you very much, everybody. Have a great day. I hope you guys make a lot of choices about masks.
Thank
Yes,
you.
thank
so
you.
much.
Thank you, Robert and Tracy. All right.
pleasure.
Take care.
All right, bye,
Bye-bye.
everybody.
Bye.